Find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
She said there was a violation.
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation. Yes, Judge. State filed a notice of a probation revocation for the defendant as to his violation of a special condition within the sentence that he received from Judge Glanville on December 8th of 2023 as it relates to his reviewing, acknowledging that the factual acknowledgments that were a part of the plea agreement in which he entered into on December 8th of 2023. I have a certified copy of the conviction for Your Honor with a certified copy of the indictment, as well as a copy of the transcript of the plea that was taken on December 8th of 2023. An exhibit within that plea transcript is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day.
Since, as you know, it's only the official transcript that is the official
transcript. All right, I'm going to switch over. Hold on a second,
I'm not quite sure I understand.
The transcript of the plea that was taken.
Yeah, I think everybody's having a sound issue.
An exhibit within that plea
this one seems a little bit better.
Is the plea agreement, which includes the sections, I believe it's sections 4 and sections 5 of the plea agreement as it relates to the factual acknowledgments that the defendant swore under oath during the plea that he had reviewed, then initialed each one of the factual acknowledgments, and then signed that he again understood and had reviewed each one of the acknowledgments that he initialed as part of the special conditions of his plea, that when called to testify, if called to testify, that the specific factual acknowledgments within the plea agreement were true and accurate statements, and that would be the testimony that he would provide as it relates to his witness testimony during the trial of this case. So I would present to the court State's Exhibits 1 and 2, as well as a USB drive of the defendant's testimony on day 124, 125, 126, and I think 127, Your Honor, but all of the defendant's testimony can be found on State's Exhibit 3. As everyone is aware, Your Honor witnessed it and can take judicial notice of everything that occurred during the testimony in which Mr. Sledge did testify. And I believe the court during, I think it was day 125, helped direct the defendant to sections 4 and 5 of the plea agreement during the testimony for him to focus on and read and to go one by one and acknowledge or disavow is the only word I could really think as to being no longer true and testifying under oath that he was violating the special conditions of his probation.
Zachary might be next. I don't
This
know.
time I would tender State Exhibits 1, 2, and 3 for the court.
All right, I'm not quite sure I understand what 3 is.
3 is a USB drive with all of the testimony of the defendant. If Your Honor wants to.
And we watched that a
preview it
couple
or
weeks
wants to
ago.
be part of the record.
Is that from the official transcript?
Well, it's the YouTube link, the live stream of all of the.
Okay, I'll just take judicial notice of it. I mean, if you want to make an exhibit, that's fine, but I'm not going to be relying on that.
So-
Since, as you know, it's only the official transcript that is the official transcript anyway, but I was here and witnessed it, so I will take judicial notice of it.
Just Whitaker hates
I'm very
media.
much aware
I
of
swear.
that. The transcript obviously is
Look at
not
the
ready
video.
as we're still in the midst of the trial.
Right.
I didn't want to overwhelm the court reporter who has been doing nothing but probably working hardest out of everyone in the courtroom. So I knew Your Honor
All right.
either could take judicial notice or
Thank you.
rewatch it. Can I approach it?
You may.
Yeah, and we reviewed this, y'all. This is gonna be
And can you try to use
Tough.
the mic, please?
Yes, Your Honor.
Can I, they go to the court reporter.
Nothing further from the state at this time, Your Honor.
All right. Mr. Wright,
Your Honor, may I remain seated or?
it's probably easy. You can. It's
he don't
probably
even want to
easier
stand
hear
up. Can we boo this man? Garbage. Absolute garbage.
you that way.
He don't even want to stand up. And there's Mounk Tounk right there.
Okay, I think I'm on.
Sheesh.
Your Honor, if it'll please the court, I believe, and I already sent to the court defendants 1 through 6. Defendants 1 through 5, I believe, were already, I think my emails between myself and Ms. Love came into evidence during our testimony.
Came into evidence in the trial of the defendants that are on trial right now.
Yes, Your Honor.
Yes.
So those are sort of resubmissions
Okay.
of those, but I do think they're already before the court, or the court can potentially take judicial notice of that.
What is your Exhibit 6? I think I
Well,
only got 5.
Exhibit 6 is the one thing, and that's just a listing of my emails in December between
Oh,
myself
that's
and
this
Ms.
one.
Probably
page.
right, Loki.
Yes.
Okay, it didn't have an exhibit marker on it.
I'm sorry,
So
Judge.
that's fine.
So succinctly, I thought it best to submit these exhibits. When you look at Exhibits 1, 2.
And those are admitted for purposes of this record, which is the probation revocation matter.
Thank you, Judge. When you look at Exhibits 1 and 2, what you see going on is plea negotiations in this case started on December 27th between myself and Ms. Love. You can see it's in the evening hours, and that's one reason I wanted to make sure that the sort of the cover page along with the attachment are part of these exhibits. At approximately 4:57 p.m. is when the email first comes in from Ms. Love. You see that the second one, Defendants 2, comes in
It's a nice jacket.
at 5:06 p.m. And at some point I respond. Those are the only 2 exhibits or the 2 drafts which occur on the 27th.
So what's your
However,
argument?
It's important to
Argument.
note that when you see the response that I send to the email at 5:06, I send that response at 8:42. And I point out specific issues with the draft that need to be revised.
Right. Yeah,
Now-
and I recall we discussed this during the trial of this, the ongoing trial as well.
Yes, Your Honor. And the point I won't belabor it is these revisions you actually see being put into the drafts. So by the time you see Defendants 3 and Defendants 4, they note that there's attachments updated to. You see that those very revisions that we requested are being put into the actual drafts. And ultimately, It was Defendant's Exhibit 4 that if you look on Defendant 6, when the email comes in, it says, use this one. That is the agreement that we thought we were executing on the 28th. And remind you,
Stop it.
Stop the cap.
He wants to. Did the state play dirty? Possibly. But at the end of the day, it's not like they initialed it and signed it and then send it back to the state and say, hey, if you need to change anything on this, go ahead and do it, even though we initialed and signed. No. That's not how it went down, Mr. Wright.
on the 28th, we're in court.
You failed your client.
I'm at my office. I can print it out, look at it, take it to the client like we did on the 27th. On the 28th,
Should have done your job.
On the 28th, both you and Mr. Sledge are in person in this courthouse, right?
correct. So the emails, if you notice, I never respond because I'm here. I'm in person.
Right.
So we would get it and via phone, or if they would give me a draft, to take to him, I would literally go from the conference room back to the holding area. We would go through it, go over it. But the one that we thought was going to be the executed final was the same one that they said on Defendants 4, use this one.
But are you testifying now, or are you just recalling,
Well,
for me, the testimony from
testifying.
previously during
It's
this
too late.
ongoing trial?
I am asking the court to take judicial notice. because
I
think
will
testified.
take judicial notice of what both you and Mr. Sledge testified to in the trial. I recall it.
Understood.
It's
So,
both of their faults, Howdy Girl.
ultimately, the last thing that I think we mentioned in our testimony was where we did take issue with some things. We said he'll have a chance to answer the question and to explain. Now, there was a big
But he is. He was. He was allowed to answer the question and explain. So what are we even talking about? And he actually did that at several points. The problem is not that he wanted to explain. Ms. Love asked him specifically, did you understand and agree to this in your factual acknowledgments? If he would have said yes, but what actually happened was this. That wouldn't have been an issue. The problem was he's like, yeah, I agree to it. Did you understand it? Yeah. Is English your first language? Yeah. Did you sit in court and we read through all of it for you? Yeah. Did you initial this line by line by line by line? Yeah. Okay. So this was the deal, right? Yeah. You signed this because you wanted to get out of jail and you're going to get 30 years probation. Yeah. But the things I signed weren't true. You don't get to do that. Mr. Wright, you don't get to do that, Antonio Sledge. The time for that had passed. As soon as you sign the dotted line, it's over.
question and to explain. Now, there was a big problem, and I noted in my testimony that
It was too late,
number
Mr.
8
Wright.
on that version that got signed had been taken out, removed. All of a sudden it reappears and it's there. My client initialed it. Yes, it was tendered. But ultimately, here's the problem. My client has always said he does not know who's responsible for shooting the victim.
Garbage.
He never was a participant or heard about planning the murder of the victim. And therefore, number 8 was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
Yeah, I'm not sure about that. That may be your contention, but
well, we would contend to the court that where my actual email.
What did he say? Hold on, let's run this back.
that may be.
Was put into evidence by Ms. Love to the court when it was a knowing statement. She knew that statement was false. That is,
Yeah, I'm not sure about that. That may
You
be
can't
your
say that.
contention, but
well, we would contend to the court that where my actual email, Defendants 2, clearly denoted that.
it does not. That is up for debate what that denotes.
It is removed from all the drafts.
Take
and then
responsibility,
ends up
Mr.
back
Wright.
in-
That is true.
So
But your response on your Defendant's Exhibit 2 to item, what is then item number 4, does not definitively state anything like what you just said. He said he did not know, as we discussed at the time of the ongoing trial, could have been interpreted in several different ways. But I understand what you're saying.
and just so I
You maintain that the two of you both missed the fact that you signed, or your client signed, a factual acknowledgement that included item number 8.
correct.
And then when Ms. Love read it out orally in the court,
Yes.
and Mr. Sledge, one by one, said, yes, I acknowledge that.
Exactly
that
what I've been
somehow
saying.
that didn't occur to you at that point in time either. So I understand what the assertion is. Here's the thing. You seem to be focused almost wholly, if not wholly, on, well, maybe there was a mistake with regard to factual assertion number 8. The issue that I see is that the state has not limited their petition to revoke probation to he contradicted or he refused to acknowledge during the trial that item number 8. It is the entirety of disavowing factual acknowledgments, et cetera. And what got disavowed under oath in this trial was far more than just item number 8. It was item number
Oh.
3, item number 4,
Number
item
7,
number 5, item number
8,
6,
and
item
9.
number 7, item number 8, item number 9,
We went
item
through
number
it.
16, and then the part 5.
This is bad.
Sentencing acknowledgments, number 1, number 2, number 3, number 4, number 5, number 6, and the paragraph underneath asserting that he's read and that they're true and that he understands that he's had an opportunity to discuss it and he voluntarily enters into it, et cetera, et cetera. So even if we entirely disregard item number 8 of the factual acknowledgments, there are still however many other ones that added up to.
Yep.
That the state
is all of them.
still relying upon. And I don't see how you get around, and maybe you have a way to get around the rest of it, and I'm certainly willing to listen, but that
can't.
one thing is sworn to in open court on December 28th of 2022, and then
I agree.
something diametrically opposite of that is sworn to under oath back on September 5th of this year.
Yeah, in simple terms, you can't violate a deal that you signed. It's not that complicated, though. And especially after you were advised by your lawyer and you reviewed it and it was reviewed to you again. If you didn't understand at any point, you could have said, stop. You say, what now? Judge Whitaker is 1000% right. He violated this whole plea deal.
I understand your concerns, Judge. One of the things that we traveled on after taking the plea was he would be able to explain his answers if he had issues.
Can I ask you a question about that? Is
He
there
could have explained.
anywhere in the guilty plea agreement in sentencing of your client in December of 2022 where you reserve that, where anybody, the state, the defense, or the court puts on the record that that's part of the understanding?
It is not in the written plea agreement, no.
All right.
However,
This man shook hands with the devil. He shook Miss Love's hand and said, yeah. Oh, you're going to let us explain this in court? Thanks, Miss Love. Garbage.
in evaluating my client for the purpose of this hearing, I don't think the state is denying that that is something that it was understood understanding it's not in the written plea agreement, but it was understood. And the other thing to also take note of, my client, when asked to make himself available, to meet with the state, to be prepared by the state, at all times would show up and do that. He was never provided or questioned it with any details such as, here, let's go over your plea agreement, these factual allegations, what questions may be asked. In other words, what you saw at trial was someone who was now, after, what was that, December of 22, was now, for the first time, being drilled, or asked questions, rather, as to the specifics of all the things that he had allocated, all the questions that were going to be asked. There was no preparation of him. So what you saw was probably frustration on his part at times, and shutting down at times on his part. But it was also part of the manifestation of what happens when a witness, who's not a lawyer, who's not someone used to this, is getting questions fired at them.
That's what you're
And
there
at
for,
some
Mr.
point,
Wright. Oh my
I think the
gosh,
court
this guy is
take note that
terrible.
He literally shut down, and some of what the court saw may be more of a manifestation of being overwhelmed as opposed to trying to purposely change or diametrically say something different than what ultimately he allocated initially. So
This is Mr. Wright. I don't know what he's trying to say here, but the issue is the plea deal. I don't know why they even brought up issues with the plea deal in the first place. I mean, I guess as his lawyer, he was kind of in a catch-22. I mean, do you tell your client, hey, you signed this, so you got to agree to everything that you signed on here. So when you get on the stand and she asks you about it, you say, yeah, I signed it. Yeah, that's what I agreed to. But not just say, oh, yeah, let me see that plea deal that I signed. No, I didn't agree to this and this and this. Yes, you did.
Retrospect, wish the state had actually more than
The issue is his lawyer and he signed.
prepped him like you would normally see a witness be prepared and prepped. That did not happen. So you saw a very raw witness.
Common sense ain't so
recounting things that
common.
happened quite some time ago, and did not necessarily say things consistent with what he said before. But it wasn't simply for a malicious intent or an intent to deceive. There were several factors, is all I'm indicating, that may well explain why it was so difficult during his testimony.
All right, anything else you want to present?
Your Honor, not at this time, no.
All right. Can the state
Anybody else you want to blame,
give
Mr.
me,
Wright?
quick rundown of what this defendant's prior history is, including any prior probation violations?
No, I think
And
Woody's
then
immunity
I
is
know
pretty
that the
solid.
probation officer is on here, so I'd probably need to, at some point, ask that officer if they would like to be heard as well.
And Your Honor, we would defer to probation as it relates to, I know they have a full account of his history as
All
it
right,
relates to.
you know what, I think I'm still on Zoom. Yes, Judge. Yeah. And what's the officer's name? That's Jolly. Oh, it's my regular probation officer from long ago, whom I haven't seen in the last 2.5 months because I've been otherwise occupied.
Yeah, we'll see what happens, Lauren.
Hello, Judge Whitaker.
Hello, I'm trying to, oops. Okay, I'm trying to get myself on video. I know. So that it's not a disembodied voice. Hang on.
Correct. Yeah, the state cannot give out federal immunity. Yeah, Woody's immunity. Woody had
All right.
a
Hello,
great
Officer
immunity
Jolly.
deal compared to this.
All right, what is probation's, can you give me a rundown of Mr. Sledge's criminal history? And I'm sure you heard the question I just asked, as well as any prior probation violations.
Well, currently, he'd used his first offender twice, one for DeKalb County, one for Fulton County.
Well, that's
The
lucky of
DeKalb,
him, since you're only supposed to get to use it once. Okay.
yes, so the DeKalb County case, 04CR24799, that was theft by receiving stolen property, felon, and a obstruction of law enforcement officer, which was a misdemeanor.
This
That
is
was
probation
May
officer.
19th, 2005. I'm sorry.
Okay.
He used his first offender. The second case, 04SC23883, that's Fulton County. He used his first offender. That was possession of cocaine, as well as a possession with the intent to distribute cocaine. That was December 10th, 2004. The possession with intent to distribute cocaine in Fulton County was January 3rd, 2014. Again, both times, all three times, he used his first offender. The next case is 15 SC 138994. That is a Fulton County case. That is the gang participation, aggravated sex battery, attempted aggravated sex battery, aggravated battery,
Jeez.
aggravated assault, criminal damage first degree, criminal damage second degree, and possession with the firearm by a convicted felon. That was January 10th, 2018.
All right, so given the fact that he had, at that point, a possession of a firearm by a convicted felon,
It's a menace.
that, indicate that at least one of those first offenders was not successfully completed?
One
Or are we
moment.
missing a felony?
One moment.
He was adjudicated guilty.
And of course, Miss Love is in the courtroom. She couldn't miss. She couldn't
That would
miss
be correct,
this.
Your Honor. In addition, of course, the current case that he is currently on probation on. As far as previous revocations,
So, hang on, so the 15 SC, and then this 22 SC case, right? Is there anything
Correct.
between the two of them?
there's nothing in between the two of them, no.
Okay. Are you looking about prior revocations or prior violations?
Yes, at this present time, I don't see any prior revocations. There was one documentation. It's a little bit, I guess, I'm having a hard time understanding what they meant by it.
Yeah, Mounk Tounk was out in these streets, man.
One moment.
Judge, while she's pulling that up, there is a 13 SC 123423 out of Fulton County. It's a BGCSA, possession of cocaine with the intent to distribute, where the defendant received 5 years probation on January 7th of 2014,
Sheesh.
which would be the predicate or basis for the possession of a firearm by a convicted felon of the
I
15
figured
SC.
there had to be something else there. Okay,
Sorry, I should have spoken
So,
sooner.
yeah.
I apologize.
appreciate it.
We knew he was dealing drugs, so that's no surprise. And he admitted to it on the stand. That's a fact.
Yeah, the only documentation that I have regarding a revocation just said revoke closed.
He was on probation.
July 16, 2008. Doesn't really show any actual time served or any time being revoked or continued on probation back in 2008.
Okay.
So I'm unsure if that's an actual revocation that was completed.
Okay, well, yeah, it sounds like maybe that it was revoked, but it was just wrapped up in something else is how I would take that. I don't know, but, or that that a violation was found, but we don't know what that was or anything like that. All right. So does probation have a recommendation in this case?
Due to the last minute notification of this
Oh, she's gonna say no.
probation revocation, I would leave that up to the courts to make that decision.
Okay.
Dang, Jolly,
All
come
right. Well,
on.
I find there to have been a violation as alleged, and again, even discounting the item number 8. What is the state's recommendation?
She said there was a violation.
In full candor to the court, Your Honor, I'm going to leave it. The state is going to leave it in the full discretion of the court. Your Honor is fully aware of the conditions. Your Honor witnessed the testimony and how it affected the trial of the case, and I'm going to let Your Honor be the full steward of deciding what the penalty should be as it relates to all of the time that Mr. Sledge still has remaining on probation.
All right. Well, I know that at least, I believe in the petition for revocation, the request is that the entire 30 years be revoked. Is that right?
Not the
Or
request.
is, you're
my
just telling
God.
me that's what he has at this point, although it can't be all of it, right? I mean, he's been on probation for at least a couple of years, and did he serve it? What's left?
He just started on December 8th of
December of
2023.
last year.
He got credit for the time. I think he was in for 2 years, so he would have
He's got 27 years
26
left.
and change or 25 and change.
I'm sorry, correct, 22.
My bad.
The exact number.
He said, my bad. Jeez. He said, my bad. I just added 4 years. Sorry. Y'all see this? Stay out of this system. This is how they handle your life. It's like, wait, what do you say? 26? Sounds good. Oh, 22? Okay. All right. Whatever. Checking off boxes,
That would
y'all.
be 27 years, 7 months, and 8 days.
All right.
That's what I thought. I said 27. He said, my
All right,
bad.
Thank you. Anything else from either side?
No, Your Honor, nothing further from the state.
Okay.
Your Honor, if it will please the court, I understand the court's ruling that there is a violation. Ultimately, I guess to some degree, while it's not clearly akin to a substantive versus technical violation of probation, it is a non-violent,
Not even close. I'll tell y'all the difference here. Hold on.
violation, and I would say if the court is going to violate my client, it would be more germane to treat it as a technical violation. We have expressed to the court different thoughts and reasons for the way the testimony came out. We don't know what effect, if any, one way good or one way bad, that has had. But in terms of his violation, I would ask the court treat it more as a technical. He has one grandchild on the way, one that just came
A grandchild?
early this year,
Dang.
with Ms. Jaquila Freeman. So the point is, he has been staying out of the way. He's been complying with probation. I would ask the court to maybe consider if you want to put more restrictions and make his probation much more of a, not just something he's on, but something that now has more teeth to it because he's been working. He's been taking care of his family. He's staying out of trouble. He's turned that corner.
For 2 years.
Literally, it was always our hope
Y'all heard that
he
rap
had to
sheet?
Come in and testify. And there was a reason the state allowed this plea to go forward so that he could step away. And in
I
doing
agree,
so,
Kel.
If you recall, you may have remember from his testimony, by no fault of his, he was a victim of a crime where he was shot multiple times and had to recover.
Has nothing
from
to do
that.
with this
So
plea deal.
we would ask the court to consider some restrictions first, as opposed to custody. And if
You're going to
do go
jail.
with custody, we would ask to consider it as a technical type of violation, not a substantive violation. in which you would be authorized to give him an even greater sentence. So we would leave it in the discretion of the court, but we're asking again for a non-custodial revocation punishment.
And what does the Honorable Attorney Kel Bell say? I wish he'd found another attorney for this hearing, or the attorney should take all the blame and say, don't punish him for my mistake. Yeah, you think Mr. Wright's going to do that? Nope. And for those of you who are wondering, substantive violations are more serious and often lead to harsher consequences, while technical violations are more about smaller rule breaks. Technical violation, this is when a person breaks a minor or procedural rule of the plea deal, like missing a meeting with a probation officer or being late with payments. These violations are less serious and usually invoke non-criminal behavior, which, I mean, he might be right in this case. Y'all let me know what you think, because a substantive violation occurs when a person breaks a major significant condition of the plea deal, like committing a new crime or failing to do something important. For example, not showing up for required court hearings or not completing court-ordered programs, not acknowledging your factual acknowledgments. It's a serious breach that affects the essence of the deal. And if you look at it, Judge Whitaker said he basically, every single one of his factual acknowledgments except a couple, he said, yeah, I signed it, but those weren't true. That's the whole reason you signed the plea deal, is to get on the stand and say, yeah, these things are true. No good.
Okay, well, I don't view it as a technical violation or akin to a technical violation, considering the solemn oath that he took when he said that he understood every term within the plea agreement, factual acknowledgments, and sentencing
Big fat
acknowledgments, and understood, and in fact orally answered that he understood, when both asked by the prosecutor and the court at his plea hearing, that a failure to abide by any of the terms would constitute a violation of the agreement, and he was notified that the entirety of his probation could be revoked. I do appreciate the
Which is
fact
30
that,
years.
This particular violation is a non-violent violation. But I also appreciate the fact that some of the many why this could have occurred include the fact that there is just not a proper regard for the judicial system and the seriousness with which an oath in court needs to be taken. I actually view this much more akin to perjury, frankly, than a technical violation. And the sentence for perjury is up to 10 years. I am going to revoke 5 years of Mr. Sledge's probation. And Mr. Sledge, I am sympathetic to the fact that you have generally stayed out of trouble, and I want to commend you for that. And I really hope that this revocation doesn't set you back. But we've got to take seriously the court system. So that's the sentence of the court. I find there to have been that violation. I'm revoking 5 years.
And
And he
reinstating
will be
the balance.
continued on probation, Your Honor?
And reinstate the balance.
Your Honor,
Thank you.
Might I ask, is it possible for my client to turn himself in to make arrangements?
Look at him getting
I
locked
think
up. That's
y'all
so
knew when you
sad.
came in here that this was a strong possibility. So, no, I'm sorry.
He must not have told him.
All right, court is adjourned.
Look how he looked at his lawyer. He looked at him like, dang, you lied to me again?
All right, court is adjourned. I'm sorry. In here
Look at
that
Mounk
this
Tounk.
was-
Turn himself in to make arrangements?
I think y'all knew when you came in here that this was a strong possibility. So, no, I'm sorry.
Mounk Tounk probably didn't even get to say
All right,
goodbye to his
court is
family.
adjourned.
Look how he looked at him. So that man got 5 years.
Good seeing you, Judge Whitaker.
Yes, thank you. Good to see you.
All right, bye.
The only person we could hear was Miss Jolly, so the only person we could hear was Miss Jolly.
Oh, wow.
Mr. Wright's like, well, steak time.
I don't know, the sound in
Dollar
this
had bad
courtroom.
luck. Go to the next room.